Hello, everyone, and welcome to the first webinar program, I think, that Clifford has ever delivered since opening the doors 14 years ago. And I might say that the world as we know it today is very different to what it was like when we opened the doors 14 years ago. Firstly, I'd like to thank everyone for attending today's webinar program. As you know from the flyer, it's the first of our webinar series in a series of 7 that will be running over the course of the next few weeks. Whilst today is really just a brief introduction on a number of the key legal areas and questions that we're dealing with on a fairly regular basis at the moment, there will be over the course of the next few weeks, obviously an opportunity for us to discuss in substantially more detail the topics that we're going to briefly touch on today. Part of the reason for that is, as you probably are all well aware, that at the moment, the information that's being released by the government around a number of their key policies are only contained in fact sheets, and the legislation that has been or will be needed to actually implement a number of these programs has not yet been tabled and or passed in Parliament. Obviously, from my perspective, being in our workplace and employment law team, one of the anticipated pieces of legislation that is at the forefront of our mind is obviously the legislation relating to JobKeeper program. And so, despite the fact that at the moment we don't have a set of legislation to provide all the answers, obviously myself and all of our other panelists will do our best to answer your questions. Now, a couple of before I go around the grounds, so to speak, to everyone who's attending from Clifford who's presenting today, to introduce each of them, I did want to say that we've received a couple of questions already from attendees, which is great. Those questions we'll get to shortly. Make sure, though, that as you think of anything that is pressing or that you want an answer to, make sure you type it into the chat box, presumably on the right-hand side of your screen, and those questions we'll get to at the end. So the format that we thought was best for today is that we'll all give a bit of a 5-minute overview of some of the key items that we're dealing with, and after that, as I said, if you have any questions, make sure you send them through, and we'll do our best to answer those questions over the course of the next hour. The first item, if people have the flyer in front of them, there's obviously 6 topics that we're going to be talking about today. The first one that I'll be talking about is the workplace and employment issues. We've got Amanda Tolson and Carly Brailak, who are our leasing and property transaction experts. They will no doubt give us a very detailed and significant rundown of the most recent press release issued by the government about 3 minutes ago before we came on this program, without wanting to steal any of their thunder. Next, we'll have Harrison Humphries, who's head of our litigation team. Harrison's going to be talking today about bankruptcy, winding up, and enforceability issues. We no doubt all anticipate, Harrison, your contribution to the program today.
Thanks, Denny.
We'll then, no problems at all. We'll then obviously, keeping going down the list, have Simon, who is going to be talking about our emerging business issues that we're or questions that we're answering at the moment, and so we can't wait to hear from you either, Simon. And lastly, but not leastly, Sheelagh Gray, who is a key member of our estate planning team. Sheelagh will be providing some very insightful and useful information on social distancing and executing valid wills. So I'm sure we'll all learn something there from Sheelagh. So without wanting to harp on the point, please make sure you do provide any questions to any of us as we're going through our particular topics. I'll start straight away now with some of the key questions that we're receiving from a workplace and employment perspective. And I've largely summarised them into two key criteria. One is questions around managing employees, as you might imagine, in the context of a COVID-19 environment. And we're also receiving a number of questions, as you might expect, relating to JobKeeper versus job seeker payments. As mentioned earlier, I'll do my best to give you as much as detailed answers as I can in relation to the JobKeeper program, but I do provide the caveat that the legislation is due to be tabled, and I would anticipate, based on the media reports at least, that they will be passed tomorrow during tomorrow's parliamentary sitting. But first, in relation to managing employees, the first round of questions that we started to receive what feels like a lifetime ago, but is really probably realistically only 3 weeks ago, was questions around needing to stand down employees because of a significant downturn in business or a loss of business, full stop, because of the immediate reactions to the spread of the COVID-19 virus. Most of you are probably familiar with the issues that we no doubt all were trying to manage at that moment in time, and that is how do you stand down, and what is the point, and can you stand down an employee essentially if their job just evaporates overnight? And I anticipate that most of you probably know already as well, because what that all seems like a lifetime ago now, is that there are relevant provisions under the Fair Work Act, particularly Section 524 of the Fair Work Act, which essentially says that an employer can stand an employee down without pay in circumstances where there's a stoppage of work for which the employer cannot be reasonably held responsible. An extension of the questions we received at that moment in time also related to, is there really a difference between standing a person down because the job no longer exists, and or is that situation really a redundancy situation? So am I required to make a severance payment to that particular individual who may have been in the unfortunate situation of having their job cease at very short notice? I guess the difference between the two is significant to the extent that when you stand down an employee, they remain a member of your team, so they remain an employee of your team. Whereas obviously with a redundancy situation, what you're doing is ceasing the employment relationship altogether. And so different rules apply when you stand someone down, as opposed to when you make an individual position redundant, and that ends up in the employee's job with the employer being retrenched. Another question that we were facing related to what's the difference between someone being forced to be on leave because of a quarantine provision or a quarantine requirement as a result of COVID-19, and what was the interplay between that type of requirement to stay home and personal leave. So where you have a person who is ill and unable to attend at work. Again, the answer to that lies in really exploring the basis upon which the person is not able to be at work. Is it because they've been quarantined and so they're not ill, they haven't been diagnosed with COVID-19? It's just a requirement for the government that the person be quarantined for a period, usually of 14 days. as opposed to someone who might be genuinely ill. And so it's important, the distinction between the two, because if you are genuinely ill, well, then your personal leave entitlements continue. Now, in terms of the JobKeeper versus job seeker allowance, obviously the job seeker allowance is fairly rudimentary to the extent that it is an allowance that's payable to someone who has lost their job and is entitled to receive what is or was eventually previously the New Start allowance. That person usually would take their separation certificate, so a cessation of employment must have occurred, and they would take that separation certificate and seek access to the job seeker payment, which included a COVID-19 top-up to take it to what the pundits suggest is a reasonable amount of money. I think $1,200 or thereabouts at the latest is my latest recollection of that amount of payment. Then we have the JobKeeper payment or allowance, which is causing some confusion, and the confusion is I think largely driven by a drip feed, if you like, of information from the government, because first we were told that it was a $1,500 payment, and that's what it was. Then we started receiving information about the eligibility criteria, and then only on Sunday we received 2 Treasury issued fact sheets that aimed to inform us further about the JobKeeper payment. Now, unfortunately, there was some conflicting information in the 2 fact sheets that were released by the Treasury, and I'll get into that in a moment. But essentially, the $1,500 allowance is exactly that. It's an allowance, and that's how you must think about it. It's an allowance to be paid to assist you as an employer to keep an employee retained. It's a gross payment, so the $1,500 is gross, so it's an amount of money less tax, and there is superannuation obligations in certain circumstances, and I'll come back to that. As most of you probably know about the eligibility criteria now, it's for most businesses assessing a 30% reduction in turnover when you compare your relevant period of time between this year and last year. That relevant period of time is determined by when you lodge your BAS return. So if you lodge on BAS on a monthly basis, then your assessment on a period by period moment is on a monthly basis. If you lodge quarterly, then it's obviously a quarterly assessment of whether you've suffered a 30% reduction in turnover in your business. Now, where I think a lot of the confusion has arisen in relation to the job seeker allowance is the $1,500 and when is it payable or how is it payable, particularly for individuals who may or may not receive more or less than $1,500 in a fortnight. If I can explain it very briefly this way, and then I can answer any questions later if that's okay, is this. So if you are an employee who earned less than $1,500 and you are an eligible employee employed by an eligible employer as at the 1st of March this year, then you are entitled to a minimum payment of $1,500. And I think the reference to minimum payment there is really important. So even if you got paid less, and just say you got paid $600 a week, you would actually receive an increase in pay. Where there has been some confusion, though, is in relation to those employees who earn more than $1,500 and whether you only pay the person $1,500 now because that's the amount of the JobKeeper allowance, or whether entitled to a top-up, so the difference between $1,500 and say $2,000, which they might have earned in any fortnight. I think the question or the answer to that question really lies in determining whether at that moment in time, is the employee engaged in work? If the employee is engaged in work and it doesn't seem to be any restriction on or requirement that it be their usual amount of work or not, but if they are engaged in work and they would ordinarily get $2,000, then you would be required to top up $500 on a fortnightly base in addition to the $1,500 subsidy or allowance that you receive. But for those employees who are stood down and are receiving nothing because they are no longer at work because of being stood down for no pay, then it seems as though what the government is now saying is that $1,500 is the maximum amount that you would require to pay those individuals. So I'll leave it there. We've got a lot to get through today, so I'll go mute my microphone and pass over to Mandy and Carly.
Good afternoon, everyone. Look, like employment law, property and transactional matters, there's a lot of change happening right now, particularly in leasing. Our Prime Minister announced some more detail, as Danny mentioned, about an hour and a half ago, which was very kind of him to do that, for us to try and wrap our head around it before this webinar. But first, I thought I'd mention property transactions. We and others in the industry that we talk to have anecdotally seen a significant decrease in the number of new transactions which are coming through in terms of property and business purchases and sales. For current contracts which were on foot when things started ramping up here in Australia, I think we all have seen a lot of contracts terminated where buyers did have an opportunity to do that, just given the uncertainty around what lies ahead. For contracts where clients do want to go ahead, there's been a lot of fear around whether settlements actually can proceed. The electronic conveyancing platform PEXA, some of you might be familiar with, it's apparently seeing a huge uptake in law firms wanting to become involved because of a lot of these fears around restrictions affecting physical settlements. We've been settling matters electronically through PEXA for a few months now, so we've been well placed at the moment to settle matters electronically. But given all law firms are not involved and not all matters can actually be settled electronically yet, for example, water allocations can't be sold via that platform, physical settlements still need to occur and they are still taking place. Large-scale settlement agencies are reducing the number of people in their physical offices. But otherwise, for the moment, it's business as usual. Our law society is continuing to advocate on behalf of all law firms that legal services should be classified as essential services. And as I currently understand it, we got some guidance through the Law Society from the Attorney General recently. Not that we're essential, but that legal services are not non-essential, as Sheelagh and I were discussing today, which is interesting. But at the moment, I guess that means we're allowed to continue to settle matters, and we don't anticipate any change in that, being able to offer our services. In terms of general commercial matters, we've seen an increase in inquiries where people are seeking advice on whether contracts are enforceable and whether force majeure clauses can be enacted. It really depends on the specific wording of contracts, so we urge people to seek advice where they need to in that regard. But leasing is really the space where we've seen a lot of change and a lot of excitement, which I'm sure my colleagues here will get a laugh out of because they often talk about leasing not being the most sexy area of law. We're really in a world of uncertainty currently. Some weeks ago, following the first forced closures of businesses, Scott Morrison advised that something would be put together by the government to assist distressed tenants. Then over the last couple of weeks, this has evolved and we keep being drip fed some detail, but unfortunately it's still not in law. So like, these JobKeeper details Danny's talking about, we are really trying to anticipate what's going to happen off the back of what's been said in press conferences and then the details in the media statements that are released after those conferences. So in terms of leasing, there was one on the 29th of March, 3rd of April, and then this afternoon, have all given some information on what we can expect. Leasing law is state-based, so each state needs to effect their own legislative change to reflect the principles outlined by the Prime Minister. And so far, they've basically been that these principles will be implemented by a mandatory code of conduct. It will apply to landlords and tenants who are eligible for the JobKeeper subsidy. So that's a 30% decline in revenue needs to be demonstrated. You need to have less than $50 million in turnover to then fall under this mandatory code. There's going to be restrictions on landlords once you're determined to fall within the code. So in addition to prohibiting landlords from terminating leases for the non-payment of rent, that was announced back on 29 March. On Friday and today, some other points that were announced include there's to be a temporary freeze on rent increases under that code. Landlords can't penalise tenants for ceasing to trade or reducing their trading hours, which is a common ability for landlords to be able to do that, particularly in retail leases. Landlords can't pass land tax onto tenants. They're unable to charge interest on unpaid rent, and landlords can't make a claim on any bank guarantee or security deposit provided by the tenant as a result of the non-payment of rent. They've indicated there's going to be assistance offered to landlords who, in Scott Morrison's terms, do the right thing. Further detail from last Friday seems to indicate that a landlord who's complying with that code might be able to access a 3-month waiver of land tax and a 3-month deferral of land tax. But again, that's state law, so we're waiting on the Queensland Parliament for that. And the focus is very much on the landlord and tenant negotiating to achieve a viable outcome. So the concept of proportional rent reduction based on the decline in turnover has been mentioned to ensure that that burden is shared between the landlord and the tenant in a fair and equitable manner. Today, some more detail was wrapped around that. Scott Morrison mentioned that landlords will be required to reduce rent proportionally to the reduction in trade, and that waivers of rent must account for at least 50% of the reduction in the rental provided to the tenant, and the balance can be deferrals, but the tenant must have at least 12 months to pay that deferred rent. So it seems the tenant's going to have to demonstrate to the landlord, this is my reduction in revenue. So they have to be more than 30% to cross the threshold to fall within the code. And then once they're there, at least 50% of the reduction in rent has to be in terms of an absolute waiver that the landlord can never recover from the tenant. And then the rest can be in terms of a deferral, which must have a minimum 12-month repayment period. But landlords and tenants can also negotiate between themselves for a longer period of repayment. So if there was 3 years or 5 years left on the lease, it can be spread out over that time frame. The Prime Minister mentioned today a binding mediation process that will be run by the states. And he again told banks that they need to sit down and provide supports to the landlords. He particularly pointed to international banks today and said they need to do the right thing, the same as the Australian banks. We've been still been hearing from a lot of landlord clients that without the banks coming to a party in a bigger way, it's difficult to see how this outcome is going to be equitable. So at the moment, it unfortunately is still a matter of wait and see what comes out of Queensland Parliament. And look, as lawyers, it's very unusual for us to be trying to advise clients on the basis of government press conferences without the law to back it up. So hand back to Danny.
Lovely, Mandy. I'll now move on to Harrison or Carly. Sorry, is it Carly you're next? No, Harrison, if I pass over to you, please, mate.
Sure. Thanks, Danny. I congratulate those on those lovely photos in the slides so far. Really nice smiles there, so that's great. Look, it's pretty obvious that many businesses are either doing it tough already or going to do it tough, particularly in certain industries like retail, hospitality, tourism, events, short-term accommodation. So insolvency, particularly corporate or company insolvency, is going to become more prevalent. It's a fact of life. Unfortunately, with the advent of COVID, the government's therefore made some changes to the Corporations Act and the Bankruptcy Act to help and encourage businesses to keep trading, to cushion the economic impact of COVID. This is specifically in the area of creditors' statutory demands and bankruptcy notices. For those who haven't come across these lovely documents, they are great tools for a debt collector. So creditors' statutory demands can be served where a business owes money. So they're able to be served on a business, and bankruptcy notices can be served on individuals who owe money. The main changes are that well, they're useful for a creditor, someone who's owed money, because you can apply to the court upon non-compliance with a statutory demand or a bankruptcy notice to force the business or the individual into liquidation in the case of companies, or bankruptcy in the case of individuals. So they're a bit of a stick to get people to pay. But you can't apply to the court to force a business into liquidation or an individual into bankruptcy until the business has committed or is deemed to be insolvent and the individual has committed an act of bankruptcy. And they only happen if you don't comply with a statutory demand or bankruptcy notice in time. For both of them, stat demands or bankruptcy notices, you used to have only 21 days to comply with them once you've been served with one. Now you have 6 months. So it's a fairly big increase in the time which you've got to pay or respond to a stat demand or a bankruptcy notice. And equally, there's been an increase in the minimum debt that the debtor must owe before you can use one of these documents. So it's $20,000 now, and that's up from $2,000 for stat demands and $5,000 for bankruptcy notices. Again, both of these measures are only temporary. All these changes, they're only in for 6 months at this stage. The other big change is in insolvent trading. I'll just find my notes here. They are where insolvent trading is where a company trades whilst insolvent, and the impact of that is the director can be personally liable for a debt incurred by a company when it's trading insolvent. And that's different to the usual situation in the sense that the company is usually the one that becomes insolvent as opposed to the director. But there's a moratorium on that, as I understand it. I had to switch screens here, so I'll just bring it up. Mandy, while I'm doing that, we had a question today from a creditor who is a landlord who was asked a question about what happens with rent that was existing before COVID came, or outstanding or overdue before COVID started. I think that would be a crossover between our section or my section and your section.
Yep. Harrison, before proceeding to recover that sort of debt, I suggest that landlord would need to just wait until the code of conduct is released. I wouldn't have thought that it's the government's intention to allow prior debts to fall under this, and effectively a recalcitrant tenant to now be protected because of what's come in. But I just think, given what we've been told by the Prime Minister, I'd suggest you just need to exercise caution, and we've been telling a lot of landlord clients that they just should hold off for the moment in terms of forfeiting security or taking actions against tenants until we actually see the detail of what comes out of here.
I think that's wise. So look, 6 months. There's a moratorium on insolvent trading. So directors are temporarily relieved of their duty to prevent insolvent trading with respect to any debts incurred in the ordinary course of the company's business. So directors are relieved from that liability, and it will apply for 6 months. Obviously, cases of dishonesty or fraud are exceptions to that rule. Any debts incurred by the company is still payable. It just prevents somebody from taking action against the director personally for that debt. So I hope that's somewhat clear. They should be considered in addition to the existing safe harbour regime for directors from insolvent trading. So this is something we've covered in the past as a firm. If a company satisfies the statutory prerequisites to access the safe harbour regime, which is basically complying with your tax obligations and employee obligations, and a director develops one or more courses of action that are reasonably likely to lead to a better outcome for the company than immediate liquidation or appointment of an insolvency accountant, and on assistance from a qualified restructuring or turnaround advisor, then you can also access a safe harbour from insolvent trading. So that was in before COVID. Equally, something that was in before COVID, which may now be more readily accessed, is for certain contracts entered into on or after 1 July 2018, the reliance on ipso facto clauses has been stayed. Those clauses being clauses that give a party to a contract the right to immediately terminate it upon an event of default or an insolvency event for the other party. So in other words, you can't terminate a contract by reason only of a party's financial condition if your contract falls within this ipso facto relief in the Corporations Act. And that was in place already, but I suspect there'll be a few more companies trying to rely on that and get into a bit of financial strife. Another thing that I'll cover next Thursday is when I do my litigation presentation or webinar will be insurance, and that's relevant for both creditors and debtors. For creditors only, so those who are owed money, I'm going to talk about being wary of increased pricing, working with your debtor in the sense of helping them, or at least making them aware of the government support packages that are out there. The stronger a debtor is financially, the more likely you ought to get paid. Trying to get some security in place with existing customers, or being very careful with the terms on which you enter into new dealings in this new coronavirus environment, and reserving your rights if you're not in a position to take action against the debtor now, so that you can take action later on when you might be in a better financial position yourself, or the debtor might be in a better financial position later on. But if you are going to agree not to sue the debtor or take action against them, putting a time limit on that and perhaps negotiating something in return. And for debtors, obviously almost the reverse applies in the sense of accessing as much government assistance as you can. There's no need to do any tougher than you have to. Taking advantage of all the law changes, for example, what Mandy covered about tenants not being able to be evicted for non-payment of rent. Taking advantage of any favourable clauses in the contract, or ensuring they're included if you're about to enter into a new one, like force majeure, and seeking to negotiate forbearance by the person you might owe money to in return for offering something else to the deal, so that you can avoid litigation.
All right. Thanks, Harrison. We've got some questions coming through thick and fast. So Simon and Sheelagh, will pass over to you now before we get into those questions. Simo?
Thanks, Danny. Thanks, Harrison. Yeah, I guess from my point of view in the startup and emerging business space, it's not all doom and gloom. There's a little bit of hope and some good news that will shake out of COVID, but I guess there's also winners and losers. The main people that are obviously going to benefit from this are those now stuck at home, thinking about their dreams, thinking about their side hustles. And I guess what they can draw upon is a sort of pattern that was established during the SARS outbreak, as well as the GFC in late 2008. And I guess the patterns there from consumers, businesses can kind of sort of start to understand and apply those prior experiences to project or forecast what is to come. I guess the complexities now are where there's isolations at home and we're ever increasingly reliant on social media and internet. So I guess concerning the COVID-19 stimulus package, you've got a series of sort of extensions of already offers from the government in terms of incentives. So you've got the R&D tax incentive deadline that was extended. the increase in the instant tax asset write-off, and then now you've also got the banks becoming a bit more lenient when it comes to deferral of payments, as well as those financial hardship claims. So there's all this is a culmination of things which help innovation or new innovation and alternative ways of doing things, and I guess birth new businesses. And as Harrison actually mentioned, the moratorium on personal liability for insolvent trading also assists with that sustained innovation. So I guess from my perspective, there's two things that will probably shake out, which is where you've got existing businesses kind of pivoting their business models and establishing e-commerce platforms or increasing their presence online. And then you've also got number two, new businesses kind of being born, which kind of focus on plugging gaps in our transition to isolation mode. So obviously we know that hospitality, travel, and physical storefronts and retailers are probably going to be the hardest hit. So I guess to change our little focus here on what opportunities there are is probably a kind of exciting time, because you've got a lot of existing businesses probably looking at cutting costs. They're jumping into panic mode and just trying to extend their cash flow during this period of shutdown. So that, I guess, from my perspective in the emerging business space, it's not necessarily sustainable, particularly when you've got rent payments, outgoings, but with new announcements, perhaps that will change, but also supply chain issues where you've got stock as well. So these businesses that are in this mode have to kind of start to think about, okay, what strategic, where can we pool our resources and pivot to change our business model, like I was saying before. So with the massive, I guess, contraction in the physical retailing space, you'll see a lot of businesses increase their spending on diversifying their products online, same with their services. And this is kind of now going to increase the importance of online-based consumers and the importance for search engine optimization. So you'll see a boost in marketing, in tech companies, in IT consultants, and basically that's a sphere where you've got this increase on consumers wanting products from online stores. Businesses can really kind of engage and measure their consumers like never before. So, and that's only ever going to keep on advancing. So you've got this kind of heightened increase in the tech, this data collection and this analytics, which can together really help boost a business when they jet off into the storefront space online. The other opportunities out there for startups, I had obviously the online platforms. I probably will see increase in app creations. So those businesses looking to go into the applications on your mobile devices, consulting businesses online, education, as basically those workers that are, you know, either being stood down or whatnot, try to upskill. So you'll see an increase in the education side of things, as well as cloud-based technology. A lot of providers will then now switch to a cloud-based operating system, whether that's a CRM or otherwise a software as a service provider. They will become businesses will become quite dependent on that, have their workers working from home. Otherwise, you'll see obviously the health, with telehealth coming into GPs and psychology services being subsidised by Medicare. You'll see that will probably shake out some pretty cool innovation in the health side of things. Then you've got home deliveries, groceries, alcohol, and then basically the demand for food deliveries is ever increasing. So what you'll see here is bars and restaurants, and you probably see it now, setting up their takeaway kind of food and drinks arms to kind of offset the downturn in the dine-in kind of eatery, if that's a word. And then you've got the issue with this, I guess, will kind of shake through stock to be able to trade. So you'll see large food distributors kind of benefiting from the takeaway food and drinks still being necessary for these bars and restaurants. Although, you know, as Amanda said, you've still got these rent payments and other ongoing costs for businesses, which if take away food and drinks are the only arm, it's going to be an interesting next 6 months really for those. Now you've got working from home policies. We'll probably see a demand in obviously the stationery and computer equipment. Again, that'll probably surpass in the next month when we all kind of move past this implementation from working from home phase. And basically, that's really the summary. So you'll see, again, existing businesses pivoting their business models, increasing their spending on digitizing their products and service offerings online. And then you've got these new businesses being born, which focus on the plugging of the gaps in our transition to the isolation mode. So those are my two big important key takeaways for anybody listening in. Is that it's not all necessarily doom and gloom when you've got new innovation coming and businesses just revisiting how they actually deliver their services. So I guess there are a lot of opportunities out there for those businesses starting up, or starting out, or even established businesses beginning something new and pivoting. And what this means is that you've got workers from home, which you probably need to think about from a business perspective in protecting your IP, making sure that those employment contracts that you have with your employees and what they're doing at home is actually being owned by the business. That's probably a very important tip as you see your workers working from home. Otherwise, where we can come in to help new businesses, established businesses starting something new is CGLaw's new branch of the firm, which is called Bolter. It's essentially a law firm targeted for startups. It's for the solo folks, for the side hustles, entrepreneurs, or the corporates. And that primarily, we've established that because we've seen a real gap in the access to services for these startup businesses, and particularly when your funds are quite tight.
Sorry, Simo, I'm going to cut you off
Sorry.
there. We need to get through everyone. That's all right. If I get another house party invitation pop up on my screen, I'm sure I'm going to delete the app. I'm not sure if everyone's using that as a medium these days to socially interact. All right, Sheelagh, we'll pass over to you.
Hi, everyone. Look, I guess I'm going to change the focus of today just a little bit, insofar as everybody's been talking about their corporate world and how it's affecting them there. And while we do a lot in structures and planning, I guess I've had more inquiries over the last few days about personal estate planning matters and those sorts of things. And there's been a interesting divergence here around what the government has been saying and what they're offering and what changes to legislation they're going to be bringing in around a lot of this corporate stuff, yet none of the personal laws seem to be changing dramatically in that effect. So there's, I guess, two things that I want to talk to you about today. The first is obviously that if your circumstances and wishes in your estate planning change dramatically, please feel free to continue to seek advice about those changes. We have taken a slightly different tact at this point in time. Instead of saying you should discuss with us every change that comes along, the reality is that for a very large percentage of the population, there is some change in their circumstances at this point in time. And we're trying to, I guess, allay people's fears that a change in a job, a change to how you run your business probably won't affect your estate plan dramatically, provided your underlying wishes and structures stay the same. So while you should take care around what your documents say and what your wishes are, there's no need to panic just because your business has had to close for an indefinite period of time or you've been laid off. The chances of that affecting your will, if it was done appropriately and properly to start off with, is fairly slim. That being said, if there is something that has changed dramatically and you do need to update your estate planning documents or start documents for the first time, we are still, I guess, open for business in that regard. We are dealing with you differently. Before, you would have appreciated that a lot of this is done in face-to-face meetings, trying to determine what your wishes are and how best to proceed and what other options we can offer to you. At the moment, we're doing a lot of that over webinar or similar to try and just, I guess, get those social distancing measures in place and all the rest of it. If, however, you do need to come into the office, we're still doing all of those sorts of things. It's just with social protocols in place. But the biggest, I guess, thing that I wanted to talk to you about today is that while there's been all these changes for other areas of law, the requirements for your estate planning documents around structures, enduring powers of attorney, all of those sorts of things, there's been no change or any indication that there will be any change around the laws for those documents. So what that really means for everybody out there is that to have these documents validly executed in a formally, you actually have to have the witnesses that you would otherwise have, so 2 people for a will and a qualified witness for an enduring power of attorney or some other documents present with you to sign those documents. There's been no indication that these sections of the Succession Act, which set out how to execute a valid and formal will be changed. And so what we are doing here is trying to, I guess, offer you opportunities around signing those documents and ensuring that you have valid documents in place if you do need to update them or if you need to start new ones, and taking steps to get the best plan in place for now, which is obviously, first of all, still remaining open and offering you the ability to sign documents with a witness in our office, or secondly, to actually sign those via a video conference together with some steps to mean that if for something was to happen to you in the short term, before a formal and document could be executed, that we have taken every step to make sure that the documents are as good as they could be for when we need to, I guess, deal with your estate, which hopefully we won't have to do. So look, I guess it's a bit of, I guess, extra work and extra consideration to be put into what otherwise would have once been a face-to-face meeting. But I guess I'm happy to assure you that we're doing everything we can to ensure that that process still flows smoothly for you, so that if you do need to change any of these personal documents, we can get that done for you, even though times are a little bit uncertain at this point in time. And then the thing that I guess I'd like to say, following on from what Simon just said about you might see some more online business solutions, is that we also have created an online business solution for getting wills done. So we appreciate that there would often be times when people would travel to our office to give us instructions or do those sorts of things, and a lot of those appointments would coincide with travel to Toowoomba for other purposes, other appointments, school delivery or drop off for boarding school children and those sorts of things. So a lot of that travel has now stopped, but we have produced an online lawyer checked will, which is available through another sub-branding of ours, which is called Gray Lawyers, and you can actually go online and have that initial interview and a simple will drawn up for you by completing an online questionnaire. It's then checked by our office and then sent out to you for signing. So while there may still be some issues around the actual signing, we're happy to say that we've at least got in place a solution around the actual instructions in the first instance. Obviously, I appreciate there's lots of questions and we're running out of time. So look, I'll cut myself off there, but we're happy to answer any questions, discuss to you how we might be able to work with you, whether you're in town or out of town, in isolation or not, and see what we can do to help you.
Wonderful. Thank you, Sheelagh. Okay, so in order of the way that the questions have come in, I think, team, we've all got a maximum of 1 minute to answer each of these questions. I'll go first. The first one is a workplace question. A business will be eligible to receive JobKeeper payments to assist in retaining their employees. What is the employer's position in directing the work their staff will do during this period of JobKeeper payment? Example, regular trade has stopped. However, would the employer would like all staff to complete a training course that takes longer, or there is other work to be done, such as stock takes, tidying up, etc.? I guess the answer to each of those two questions very briefly is they would both be circumstances where an employee is engaged to do business or to do work, and the job seeker payment would be paid to subsidise you for the hours that the employee would do in undertaking those tasks. So if they would ordinarily get $2,000 as my example before, they would be entitled to that in my view because they are engaged to work. Are there any restrictions on the type of work the employer can direct the staff to do? Short answer is no. So long as it's not unlawful or it's unsafe to do that particular work, then you can, within the reasonable expectations and skill level of the individual, ask them to do additional tasks or alternative tasks to what they might do now. Mandy or Carly, I'll pass over to you. There's a question which I think you've seen relating personal guarantees. If either of you could answer that question, please.
I can take that one, Danny. So the question is, if a business is unable to pay monthly rent, the landlord is going to give some reduction in rent and maintain outgoings at the current amount. If, however, we are unable to pay the reduced rent, is there a point we can ask the landlord to utilise the personal guarantee? And if so, how do we initiate that action? I guess when we're talking about personal guarantee in that context, I assume that you mean a bank guarantee that the landlord can call upon. That being the case, I wouldn't actually recommend that course of action to a tenant at all at the moment, because landlords effectively can't take any action for 6 months in terms of kicking you out, charging you interest on your rent, or calling on your security. So hopefully that 6-month period will give you an opportunity to trade out of the circumstances that you find yourself in. And you'll all be pleased to know that the Commercial Tenancies Code has been released while we've been on this webinar. Amanda will be pleased to know it's only 7 pages. We may have actually wanted a few more pages with a bit more detail. It might have been handy, but no doubt we'll absorb that after we get off this webinar and be in a position to advise everyone more specifically. But yeah, as a tenant, there's no motivation on you at the moment to ask your landlord to call on your security.
Excellent, thank you, Carly. Harrison, how do business owners go about terminating a contract if the business can no longer complete it?
Sorry, I just missed the end of that question.
How do business owners go about terminating a contract if the business can no longer complete the task?
Well, you would hope that the contract has a mechanism or a clause within it that allows them to terminate. Without such a right to terminate in the contract, you'd be relying on equity or frustration or some other general contractual principle, which gets a bit murky and grey. Force majeure is the best option in the current climate, and that means where the contract is unable to be performed due to circumstances outside the control of one of the parties or the person who has the obligation to do do something under the contract. That would be your best bet, subject to, of course, all of the law changes that are in place at the moment. But I take it the question assumes that none of those apply. Does that answer, do you think, Danny?
I think so, mate. And while I've got you, another question that I think applies to you is, what other avenues beyond statutory demand and bankruptcy notices will my business have to try to get paid given my limits on my cash flow?
Look, you, as I understand it, you still have the option to start a court proceeding against the debtor who owes you money, but that can be expensive depending on, and even uncommercial depending on the size of the debt that you are you are seeking. Otherwise, you've got a letter of demand with or without the assistance of a law firm. I don't think any of those have been outlawed. So, and you still got the ability to call your debtor, again, with or without the assistance of a solicitor. I'd be trying to find out as much about the debtor as you can to see whether they're entitled to any assistance. Urge them to take that assistance, which will improve their cash flow, and just get something. If something is better than nothing, if that business or individual ends up going bankrupt or into liquidation, well, then the liquidator or bankruptcy trustee might come back after you and try and claw back the payment that the debtor made to you, if it was made within a certain period of time before they went or became insolvent. But possession in 9 tenths.
I was going to say the other, a potential solution which may or may not be palatable, is to access the relatively cost-free loans that the banks are being encouraged to offer via the money made available to them by the federal government. That might be an interim measure to get you through those periods where cash flow is tight and enables you to be a bit more flexible then with your clients about getting paid, I guess.
Yeah, I think that's from the perspective of the creditor. You're talking about looking inwardly first before looking outwardly to the debtor. Yeah, I think that's fair.
Okay. Couple quick questions. One's an employment question. Can you make an employee work set hours if they choose to work from home because of school closures? I guess if they're an award-based employee, usually a change to the hours of work are only able to be changed or encouraged to be changed, I should say, via the consultation provisions contained within an award. I do note that the Fair Work Commission has recently issued variations to hours of work in some awards, particularly, for example, the Private Sector Clerk Awards, which allows ordinary hours of work to be worked through until I think about 11 o'clock at night, to give people, employers and employers alike, the flexibility to do ordinary hours outside the usual hours, which might be between 6 and 6 in any one day. There is one further question which someone has asked regarding essentially a comparative analysis between the UK, New Zealand and French strategies of sending economic stimulus to the community rather than via employers. Whoever's asked that question has just created nightmares for me from a comparative IR subject I did back in the 90s. I'll answer that question in more detail when I present the webinar this coming Thursday. So we're right on time. So everyone, thank you very much for your attendance. We hope, that you found everything that we've told you today of some use to you and your personal circumstances or the circumstances of your business. These are very trying times for everyone, and so identifying or accessing these types of webinars, I think, where you can try and get information, obviously for free, from people that we hold out to be experts in our fields, we would encourage you to do. I'll note that Sheelagh and Simon have unmercifully plugged a couple of brands that will no doubt become more known to each of you over the course of the next few weeks and months. It's our way of having put in place systems in the past to try and make sure that we remain ever changing and able to meet the needs of all of our clients. So once again, thank you everyone for your attendance. I'll be back on Wednesday. Thursday, sorry. If anyone has any questions in the meantime, I'm sure we can put a flyer together to answer any questions that anyone might have. So feel free to email any one of us. But for now, thank you to those also behind the scenes, John and Carolyn, who have put all this together for us. You've done a sterling job. I think it's all gone relatively smoothly, being our first webinar undertaken by Clifford Gouldson. So thank you. We'll switch off now, and hopefully everyone has an enjoyable afternoon. Thanks very much.